Hello, this is Matt on the Moon Lambo channel. Why is XRP important? That's the question posed by Jason A. Williams, who is a self-identified Bitcoin maximalist, as you can see on the screen here on Twitter. He's also the author of a book called Bitcoin, Hard Money You Can't F With. So he doesn't think that there should be any coins beyond Bitcoin, just the one. And why? Because it was the first. And because of reasons. You see how that works? I hate maximalism. It's so completely ridiculous. But the truth is that he doesn't think XRP is important, and the reason he asked this question, I believe, is for social media engagement from his followers. So that's what I think anyway. And he does have almost 200,000 followers on Twitter, so he's pretty well known in the crypto space. He's been around for years and years and years and years. But the reason that I wanted to highlight this is because, well, it's always an interesting topic. And it is fun going through these threads because you'll have the troll people who are just completely ridiculous and anti-XRP and all the nonsense there. But then you'll also have a lot of people from the XRP community. And there are responses from attorney John Deaton, as well as a former Ripple employee. So I thought I'd share with you just a few thoughts on this topic for fun. But XRP is very important. And I argue, and I have been arguing this for many years, it's one of the only cryptocurrencies in the entire space out of roughly 20,000 freaking coins on the damn planet, son, that actually does something. It's actually solving real problems for real people and used in enterprise-grade software today. I also want to share with you a chunk from this article. It's a Forbes article titled "The Supreme Court's Wrecking Ball Could Impact SEC Authority." And it's another article that takes on an interesting idea to me. What happens if Ripple loses its case against the SEC? What would that mean? And if that happened, and the Ripple case made it to the Supreme Court, what would that actually result in? Well, I'll tell you here, I'll tease it a little bit in the intro of the video. The author here, who is a chief legal officer for IOV Labs, don't know what that is, so presumably an actual lawyer, she wrote this article, and she seems to think that it could result in the SEC losing a substantial amount of power. Now, not that I want to see it go that far, because that could be another 5-7 years out, just from this point in time. But if it did happen, I think it would just strip the SEC. But see, look, if it were going to come to that, I mean, my gosh, can you imagine what would have happened in the meantime, and how many other cryptocurrencies would have been sued into oblivion in the meantime? So before going any further, though, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. So here's some thoughts from attorney John Deaton. He retweeted that question from Jason A. Williams, why is XRP important? And attorney Deaton responded with the following. The answer to Jason's question is an easy one. The SEC's argument regarding XRP makes XRP by far the most important altcoin in crypto. The SEC is alleging that today's XRP, the token itself, is a security, including secondary market sales, independent of Ripple. Now, considering Congress is not going to provide regulatory clarity, especially in an election year on the heels of the Supreme Court overturning Roe, the ruling by Judge Torres in the Southern District of New York will decide whether the SEC has jurisdiction over the existing altcoins that have traded for years. Yeah, so I'll just pause to note here. If the SEC has jurisdiction over everything, I will start to feel very, very, very concerned. I will be wondering which of my other cryptocurrencies will be attacked by the SEC next. There's just so much at stake here. And then attorney Deaton also said, and this is a key takeaway, he said, the SEC is not only alleging the way Ripple offers and sells XRP is illegal, but that all XRP are unregistered securities. It's the functional equivalent of claiming the oranges or the orange groves in Howey were securities. If successful, then almost every other altcoin is a security. Yeah, exactly, just by the nature of it existing. And that's why so much is at stake here. And you can see that's why the SEC has gone back on whatever it is, 70 some odd years of legal precedent in Howey. And they're now stating that the underlying asset is the security that goes against 70-ish years of legal precedent. Because this, mind you, Howey, this case dates back to 1946. And then Attorney Deaton also wrote the following, and he shared this article. I'm not going to read this article, but I'll just note what he was sharing. It was a piece from CoinDesk titled, Solana Labs Multicoin Accused of Violating Securities Law by Solana Investor. So it's another one of these things where individual purchasers of a coin are attacking. This is not the SEC currently suing Solana, although that's not off the table either because the SEC is completely bonkers. But think about this. John Deaton shared something here that I hadn't really ever thought of quite in this way. Maybe some of you have, but I actually hadn't, to be honest with you. But here's what he said. I can tell you this with 100% certainty. If today's XRP is deemed a security by Judge Torres in the Southern District of New York, the amount of class action lawsuits that will be filed against the promoters of existing altcoins along with the exchanges will be unprecedented. When I filed the motion to intervene on behalf of XRP holders, I said not only should the exchanges not delist XRP, they should hire a lawyer to file their own motion to intervene or alternatively be allowed amicus status. You cannot underestimate the impact this case will have. Yeah, so a few things on that. It is unfortunate, but I understand that why the individual cryptocurrency exchanges out there, almost all of them in the United States, tuck the tail between the legs, and we're like, yeah, let's try to not get sued by the SEC. Just, don't want to show up on the radar, right? But the problem is, if the SEC gains even more power, they're just going to attack that much harder. So by not pushing back right now, there is a possibility that it could really bite them on the rear side. So I understand why they're saying this is the most legally prudent thing to do, but that doesn't mean that things can't get way worse as a result. And so as far as the part where I said that I hadn't quite thought of it like this, well, obviously I have said many times that I'm worried about which of my cryptocurrencies will be attacked next by the SEC if Ripple loses, because it's going to be precedent setting here. But I hadn't thought about the fact that it's just going to open up the floodgates in terms of every altcoin on every exchange in the United States, certainly, getting attacked. So when John says it's unprecedented, that's what he's talking about. And I hadn't ever thought about it quite like that, although, of course, I understand in a general sense, and I always have, what's at stake here in terms of opportunity for additional litigation here. And then we have former Ripple employee Matt Hamilton responding to Jason Williams' question, why is XRP important? Matt Hamilton wrote the following. Because it is one of the few cryptocurrencies that is gaining real-world adoption. It is one of the best cryptocurrencies to use for payments and transfer of value. Because the XRP ledger is still one of the best blockchains for tokenizing other assets. Yeah, and that's his tweet. So not only that, so yes, XRP Ledger also the first cryptocurrency our blockchain platform ever in existence to have a built-in decentralized exchange on which you can tokenize assets. And there's a really good chance that the adoption of that technology is only going to increase if, in particular, if XLS 20 gets passed, which is an amendment. I won't be talking about it in depth in this video, but I've been mentioning it lately. If that amendment gets passed, you're going to have on layer 1 of the XRP Ledger native, well, technically you can do it now. Like you can mint NFTs, don't get me wrong, because you can tokenize stuff, but you're going to have a native functionality on layer 1 of the XRP Ledger that currently doesn't exist, and it will make it a lot more appealing to launch NFT-related projects on the platform. And it's not just about overpriced JPEGs, I promise you that. There's a lot more to it. You know, you can think even in terms of pick an industry like music, for example. You can actually put royalties on the blockchain and have everything automated right there. And then if there's a sale of something, like it's all there in one spot. Just even that makes the process of transferring ownership of anything from one party to another that much easier. And of course, yeah, it's true, garbage in, garbage out, so you need to make sure the correct information is put in. But the point is, even just having that detailed record that is incontrovertible because the XRP ledger is immutable, even that's a game changer right there. XRP ain't going away, my friends. And then there was this, somebody who is a troll, part of the, this is like a, room temperature cottage cheese eater, Velcro shoe wearing, helmet wearing individual who needs assistance from another creature to get its shirt on in the morning. This individual responded to Jason Williams' question, why is XRP important? And wrote, because banks are people too, with a little clown face right there. So he's trying to be a little bit snide there. That's the attempt, at least. Well, Ripple employee Matt Hamilton responded with the following. The slogan of the original Ripple project that became the XRP ledger was be your own banker. The whole point of the XRP ledger is you don't need banks. Yes, I'll just pause to note that the creators of XRP and the XRP ledger were merely seeking to create a better version of Bitcoin. That was it. That was the mission. They didn't even know exactly how it would be used, something loosely with payments. David Schwartz has talked about that. But they didn't know beyond that. They just wanted a better version of Bitcoin. They were early Bitcoin developers. And then Bradley jumped in and said, can't we achieve that with Bitcoin? So, here you go. Here's the mindset again. But we could do it with a different thing. And why Bitcoin? Because it was the first. That's it. That's as far as the logic goes. The arguments from Bitcoin maxis are so disingenuous and so shallow that, at least as a result, they're amusing. Matt Hamilton then responded to that and wrote, well, you could do, but all these years and not done yet. The XRP ledger is faster, cheaper, more scalable, and more decentralized than Bitcoin. Let's pause to think about that. How is the XRP ledger more decentralized? Well, there's a lot of stuff that you could do, and I'm not going to put words in Matt Hamilton's mouth. He can easily defend himself, and he has quite a strong tech background on top of that. But I'll just say this. Some people, they make this really lousy argument, in my opinion, that because there are a lot more nodes on the Bitcoin blockchain, and there are only so many validators on the XRP ledger comparatively, that Bitcoin blockchain must be more decentralized. And I sit there going, no. It would be much easier to take over the Bitcoin blockchain because there are just a handful of mining pools that could collude, come together, and gain 51% power, and then bam, it's over. There you go. Don't tell me that can't happen. Now, I'm not arguing that Bitcoin is centralized. I'm not. I'm just saying, if you compare that to validators on the XRP ledger, there is no comparison, right? There aren't huge mining pools. Mining results in a situation that is less decentralized than it other would be. That's the argument that I'm making. So yeah, you can talk about how there's, compared to Bitcoin miners, compare that to validators on the XRP ledger. Fine, there's far fewer validators on the XRP ledger, but it doesn't matter. You think that the dozens of the validators are actually going to collude? That's more likely than a handful of entities on the Bitcoin blockchain colluding? And then the threshold being 51%? You ever heard of a 51% attack, folks? Of course you have. So that's why when people say that Bitcoin's, more decentralized than anything else out there, I just think either bold-faced lie or, do some more research, because that's just not accurate. And again, I do believe Bitcoin is decentralized, but it's a question of to what degree. And I don't think it's likely that these mining pools are going to collude, but it is possible. It's not impossible. Just acknowledge, why can't we just live in reality and acknowledge that? And then there's also this. Somebody had another snide comment, somebody named Tatiana, she wrote, who said XRP is important? Implying, obviously, that XRP is not important. XRP community member Zerp589 on Twitter responded with the following. Investment bankers at Citigroup, a handful of Fortune 500 companies' senior advisors, chief economist for Microsoft Corp, SBI, senior advisors of BlackRock, chief reg at JP Morgan, FDIC members, two-time senior advisors of the White House, former treasurer of the United States, etc. Yeah, so I thought that was a good response. Who says XRP is important? There's a few. There's a few right there. And I don't know why Moon Lambo's not on the list. That list should have been started with Moon Lambo, and I'm very offended that it wasn't Zerp. No, I'm kidding. But it's true. There are a lot of highly intelligent people in important spots the world over that think XRP is important in the space. And then somebody named T. Smitty responded and wrote, don't forget MasterCard CEO, SBI CEO, and MoneyGram CEO. Thanks to ETHgate and the deep pockets that follow, SEC threw out a BS lawsuit stating that XRP, the token itself, is a security. Not one token, in my opinion, is a security. It's the companies that use them and the ICOs that are. Yeah, and so in a general sense, I think that's correct. ICOs, generally speaking, certainly those do look like securities offerings. But yeah, it's just the idea of the underlying asset being a security that's so damn absurd. And so then there's the Forbes article, and I'm telling you, I would so prefer for there to just be a damn settlement. I really would like for there to be a settlement in the SEC versus Ripple case. If it goes further, it goes further, and we'll just have to make do. And I don't think we're ever going to see the Ripple case at the Supreme Court, but I acknowledge it's possible. So this article is titled, The Supreme Court's Wrecking Ball Could Impact SEC Authority, written by Andrea Teniano, if I'm saying that right. No, I'm probably not. She's the chief legal officer for IOV Labs, so presumably a lawyer. And I want to share with you a chunk of this. Several recent decisions from the U.S. Supreme Court raise new questions about whether the SEC's authority to regulate crypto markets may soon be curtailed. The court's recent hair-raising decisions, including the elimination of the constitutional right to abortion, toppling 50 years of precedent set by Roe v. Wade, the expansion of gun rights, striking down a New York law limiting gun carry outside the home, and the most recent ruling restricting the Environmental Protection Agency's ability to limit power plant emissions, have gotten the attention of blockchain attorneys. They are looking ahead to the lawsuit brought by the Securities and Exchange Commission against Ripple for failing to register the company's sale of XRP as a security. And they are all asking the same question. Will the SEC get to decide the future of finance? Now, some are not so sure. Kevin Sadeghi, partner at Jenner and Block, explains, quote, the SEC's approach to crypto assets relies on an expansive interpretation of its own authority. For example, the SEC seeks to characterize digital tokens themselves as securities, even outside the context of any fundraising, without a clear basis in current law for doing so, end quote. So look, part of the argument you'll see as I go through this a little bit further, and forget the political stuff. I'm not going to talk about that. That's not what this damn channel is for. I don't care what you believe. Maybe we agree, maybe we don't. I don't care. That's not what this is for. The point being made here is that given, let's say, the decisions that have come down recently, the direction that this author believes things are going would result in anything if the SEC losing the power that it has. Now, it shouldn't have this power, as I was citing earlier in the video. Oranges themselves are not securities, and so the SEC claiming anything to the contrary, replace the word orange with XRP or pick your digital asset. The fact that they're doing that goes against decades of precedent. The SEC is going against precedent. They can't be allowed to get away with this. Piece continues. He further explains that some trial courts may defer to the SEC's interpretation of what constitutes a security based on Securities and Exchange Commission v. W.J. Howie Co. and its progeny. But the Supreme Court may not go along. Sadeghi says, the court, this is a quote, the court has demonstrated that it is critical of expansive regulatory authority. So if a crypto case makes it to the Supreme Court, the decision may have little to do with crypto and focus instead on questions about the power of regulators more broadly, end quote. And I'll still pause and note that it's frustrating that if Congress had just done its damn job, we wouldn't even have to talk about the Supreme Court potentially coming in to settle crap like this. Because Congress has the power to determine who's in charge of what and the powers that they have. Just pick your government agency. That's just how it's set up in the United States. And it's not clear. And so that's, as a result, you've just had the SEC saying, okay, we're in charge of everything crypto then. It's completely BS, but that's what they're doing. Piece continues. Josh Clayman, U.S. head of fintech at Linklaters, emphasized the importance of stare decisis. That basically just means precedent. Stare decisis, which provides trust and predictability in the law. She offered that a principles-based approach, quote, provides for flexible application to a wide variety of previously unforeseen technologies and circumstances that may arise in the future without having to come up with an entirely new law, end quote. Now, Clayton continues by stating, quote, at the time of Howie, who could have predicted the rise of digital assets and tokens? Yet, we still can apply the Howie test to determine whether an investment contract exists under U.S. federal securities law, even though the drafters of the Securities Act and the Exchange Act never mentioned and probably never contemplated crypto or ICOs, end quote. Exactly, which is why some people say that Howie shouldn't be applied. I'm willing to be persuaded on that for sure, but I disagree. I think if you could just have policy set in place that determines when something is sufficiently decentralized, that you're like 90% of the way there in solving the problem, because if something's sufficiently decentralized, then there is no common enterprise, which means one of four prongs of the Howey test isn't satisfied, which means that the asset is not a security. So I don't think you have to take a hammer to everything, but absolutely additional clarity is necessary. It's required in order to settle this nonsense. Piece continues. Still, the SEC's approach to regulating crypto assets through non-binding guidance and enforcement actions, but not rulemaking, could be undone by the court. Sadeghi warns that, quote, any loss for the SEC could therefore threaten not just its authority over crypto assets, but the scope of authority for the SEC and regulators overall, end quote. Now, Jason Gottlieb, partner at Morrison Cohen LLP, agrees. He suggests the following. This is another quote from Mr. Gottlieb. If Ripple loses at the district level and appeals, the Second Circuit could go either way. But if the case goes all the way to the Supreme Court, there could be a frontal assault on Howey, like what happened to Roe v. Wade. End quote. Or, Gottlieb continues, the court could invoke the major question doctrine outlined in the recent EPA decision to find that the central question in the Ripple case constitutes a major question. If that were to happen, the SEC could lose on that ground alone, finding that the SEC does not have the authority to make that determination. Now, either path could be a long shot, but either could happen, especially depending on the question presented to the court. If the court determined that the question in Ripple is not whether XRP is a security, but instead, does the SEC have the authority to set policy for the future of finance, it would certainly find that to be a major question, Gottlieb said, potentially gutting the SEC's enforcement powers. So look, on this particular topic, if it came to that, I'm willing to bet that just about 100% of people listening, or 100% literally, would agree that would be fantastic, because the SEC is an asshattery. It's a factory for asshats, where asshats are actually produced. And where they come. There are other assets that exist, and they come to that factory. They want to be around other assets, and they make more assets. Piece continues. In fact, the SEC's broad authority is already being chipped away. The Fifth Circuit recently ruled in Jarchezi versus SEC, a fraud case, that the SEC's administrative enforcement proceedings are unconstitutional. And in that case, the court held that the SEC's agency-adjudicated enforcement action violates the Seventh Amendment's guarantee of the right to trial by jury, among other constitutional defects. More challenges to the SEC's authority loom. Grayscale Investments recently brought a lawsuit against the SEC based on the agency's rejection of its application to convert its Bitcoin Trust GBTC into an exchange-traded fund, or ETF for short. This application is just one of many that the SEC has rejected in the last year alone. If the case doesn't settle, the SEC may have more to lose than just this case. So I think that's a good stopping point for that. But it's going to be so interesting as we get closer and closer to the end of the Ripple versus SEC case. There's going to be a lot more discussion about potential outcomes, what it might look like for XRP under various scenarios, and I'll be happy to cover all of that, all the opinions, perspective from various attorneys within the XRP community and even out, anybody that's talking about it. I always find these perspectives interesting, in particular if it's coming from attorneys, because that's the type of insight that most people like myself included, since we don't have legal backgrounds, we can't really pontificate too much about such topics. Other than what we learn from other attorneys, we can kind of share those ideas, and yeah, you can form your own personal opinions based on that. But I'm just saying, the type of insight that is most interesting, it comes from those folks. People like Attorney Hogan, Attorney Deaton, Attorney Rispoli, just a few, James Filan off the top of my head, just named several within the XRP community. But, what are the odds that if this is settled, for example, cryptocurrency exchanges will just suddenly relist XRP? Is that actually going to happen? I'm somewhat skeptical because there could be appeal. Will they wait to see what happens? I don't know. I would hope that they just relist it, but there's so many ways that things could unfold, and then the implications of all this for XRP holders. We're going to be talking about this for some time, unless out of the blue we actually get a settlement, which still is possible. But even that, if it does happen, even that would probably be a few months away. We need to see what happens with the attorney-client privilege arguments that the SEC is making, claiming that Bill Hinman's the email surrounding Bill Hinman's Ethereum free pass speech actually constitute attorney-client privilege. So I think that's going to get slapped down by Judge Netburn. That'll probably be appealed to Judge Torres. But, let that play out. That's probably what's going to happen. And from that point on, inside of a few months, don't be surprised if there actually is a settlement. And Attorney Deaton has said as much. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.